So yesterday we discussed something from Unit 3 relating to HIBA. So there are a few more provisions that we have. We'll discuss that part today. Okay. So have you seen these Wakf boards, which are very common amongst Muslims somewhere around you?
Not physically, at least I have heard about such things, like where they've involved in this Dwarka case.
Yeah. So there is this concept with regard to Wakf also. These provisions are a little similar with trust that we have. How powers functions quite similar with trust. Okay. So regarding Wakf under Muslim law, it is for religious or some pious obligation, but there may be certain cases wherein for other provisions also such boards or such bodies may be appointed or such bodies may be created by Muslims. So under Muslim law, there are several religious institutions for which a Wakf may be created. And most common ones are for mosque, graveyard, dargah. For all those also they can create. For some specific religious purpose, might be for teaching some religious practices and all also. It may be created by people. So there is one legislation also called Wakf Act 1954, which defines that Wakf means the permanent dedication by a person professing Islam of any movable or immovable property. Sometimes some movable properties may also be donated for some purpose. So it might include both movable as well as immovable property. And if we look at the definition, it clearly mentions a person professing Islam for the purposes recognized by Muslim law as religious, pious, or charitable. So it should not be for something which goes against the principles of Muslim law, but rather whatever Muslims believe on, for those principles, if something is being permanently given, in such cases, we would call it as Wakf. But then in the definition, it clearly mentions person professing Islam. That does not mean that the person has to be Muslim only. Courts have recognized that it's fine even if the person is non-Muslim, even if the person is Hindu or some other religion also, but that person has donated the property, movable or immovable. And the reason, right, that reason goes with the principles of Muslim law. That means it's not like literally the person has to be Muslim, but rather if the purpose or something for what this property is being donated, that is with regard to this religious practices or beliefs of Muslims, if it is going in that direction, then also it can be recognized as a valid Wakf. So if we look at the definition, it clearly mentions professing Islam, but it's not needed that that person has to be a Muslim only. If someone's intention for donating the property goes well or fits well with the Muslim principles and things, then also it is fine. That also would be recognized as valid. In trust, we saw that author of the trust, he should be competent to create the trust, plus he should be having right to give the property also. I cannot randomly pick any property and create a trust. I should have right over that property, plus legally I should be eligible to enter into a contract or donate such property and stuff. Same applies here also. Competency of Wakif is very important. The person who constitutes Wakf of his properties is called founder of Wakf or Wakif. Wakif must be a competent person at the time of dedicating his property for Wakf. For being competent, Wakif must be a person who possesses the capacity as well as rights to constitute the Wakf. So first of all, he should be competent. based on the provisions of Indian Contract Act. And secondly, he must have the right as well. He should be owner of that property also, which he is donating. So competency of parties as well as right is needed for Wakf to be competent or for the Wakf to be valid. As regards to capacity of Muslim for making Wakf, there are mainly two requirements. First of all, person should be major, and secondly, of sound mind. So person of unsound mind has no capacity to create any Wakf because he or she is incapable of knowing the legal consequences of such a transaction, that you are permanently giving or permanently donating your property for that specific purpose. So simply a person of unsound mind who is not able to understand the nature of that transaction, that person is considered as incompetent to enter into such a transaction. Wakf constituted by an insane or minor person is void. Even a minor is not entitled to know the or understand the consequences of such a transaction. So those are considered as void. The person will have to be a person of sound mind. Plus, he should be able to understand consequences also. For that reason, it's very important that the person is major, capable of understanding nature of the act. This basically same provisions of Indian Contract Act to apply what is otherwise competency of parties. Wakf by non-Muslims. What will happen if the Wakif or author of the Wakf is non-Muslim? He is not a Muhammadan. The dedicator must profess Islam, that is, believe the principles of Islam. Your thinking or your intention should not go against principles of Islam. If it is going in the same direction, that's also it's fine. He need not be Muslim by religion. Religion is not important, but that thought process is important. It should go in that same direction only. Madras and Nagpur High Courts have held that non-Muslims can also create a valid Wakf provided the object of Wakf is not against principles of Islam. Because main purpose of creation of this Wakf is in order to fulfill or practice those principles which are being given. So if for that specific purpose only a property, movable or immovable, is donated by a person, even if that person is non-Muslim, it's completely fine because it is for that specific purpose only, for fulfillment of those specific principles of Islam only. So that is also fine. We also have legislation Musalman Wakf Validating Act 1913 and Wakf Act 1954 contemplated that Wakf can be created only by Muslims. Similarly, Wakf Act 1954, like we saw the definition, that also says that permanent dedication by a person who is professing Islam. But courts have said that it's fine even if it is by a non-Muslim who has created this trust, the Wakf, that is also fine. The object should be lawful and it should be in conformity with the principles or beliefs of Islam. If it is not going against those, then it is completely fine. We should not be much bothered about religion of the person. Patna High Court also has said the same thing. So basically these rather than religion, even if in a legislation something is being mentioned, courts are having the power to explain or elaborate or interpret the provisions in a much detailed sense. So they basically elaborated or interpreted it in such a way that professing Islam just means that your thinking should not conflict with principles of Islam. If that is not happening, religion is not relevant. It is fine. You can give a certain property for that specific purpose also. It will also be considered as valid. Right to make Wakf. A person having capacity but no right cannot constitute a valid Wakf. Even if you are having all the essentials for formation of a valid contract, but you do not own the property. In such cases, that Wakf will not be considered as valid. Apart from competency of parties or capacity of parties, we also need that the person has a right to create the right over the property. Also, he has a right to donate the property. Subject matter of Wakf should be owned by Wakf at the time when the Wakf is made. When the property is being donated, at that point in time, the person should have possession over the property. That person should have ownership of the property. It should not be that in future I will be getting this property. Like in case of mortgage also we saw, right, that one person cannot like mortgage a property simply because he is in that line of descendants that next I am going to inherit this property, so now itself I am mortgaging. That should not happen. At the time of donating, this person should be complete owner or absolute owner to take a decision with regard to the property. That is very important. Whether a person has right to constitute Wakf or not depends on the fact whether the dedicator has a right to transfer ownership of property or not. Simply having possession, simply being owner is not enough. Are you the absolute owner having absolute right to transfer the property or not? Or is it's a joint ownership wherein permission of both the two persons are needed? Those things also will be considered. If it's complete ownership, the person is entitled to donate the property, and that person decided to donate it for some principles, for fulfillment of some principles of Islam, then it would be considered as valid. A widow cannot constitute a Wakf of property which she holds in lieu of her unpaid dower because she is not an absolute owner of the property. So what is being promised with regard to that? She cannot make a Wakf because it's not yet being paid to her. It is just a promised amount. So basically, whenever a person is donating something, he has to have the absolute ownership over the property. It should not be a case of joint ownership, or it should not be a case that I am having possession and everything, but to transfer it, I would need permission of someone. That should not happen, but rather I am the owner, I am completely donating it. Or if it's a joint ownership, both the two persons together decided that yes, we are donating this specific property for so and so purpose. So that intention thing is very important, whether they are willing to donate the property for fulfillment of some principles that Islam believes on. Okay, so at the time of donating, the person has to have right also to make the or donate the property.